So we've just covered rules of attribution on state responsibility and finished with the idea that a state is responsible for the acts of private individuals and entities where and to the extent the state acknowledges and adopts the conduct as its own. So in the Tehran hostages case, it was writing students who seized the US embassy and the personnel within, but the government of Iran then publicly endorsed and adopted that course of conduct, making it responsible for those acts. So that's attribution. In the remainder of this third recording, I want to deal briefly with breach and defences. So simply put, a breach of an international obligation by a state is an act of that state which is not in conformity with what is required of it by that obligation. Article 12. An act not conforming with your obligations. However, to note the obvious, the obligation must be enforced for the state at the relevant time. You can't breach an obligation which you are not bound by at the time you acted. However, breaches may also be continuing. So in the Rainbow Warrior case, for example, every day the French agents were not held in detention following the agreement reached between France and New Zealand, was a continuing breach of that obligation. Also, a breach may be made up of more than one act. It might be a series of acts that gives rise to the one breach. So it could be a composite act. Now, generally speaking, international obligations all sit at the same level. They're all of equal value. However, Article 40 and 41 deals with the exceptional case of serious breaches of obligations under peremptory norms of international law, what we've previously discussed as questions of jus cogens. So it's serious breaches of peremptory or jus cogens norms. So we've got a dual criterion there. It's got to be a jus cogens obligation and a serious breach. And in those cases, there are special consequences. So where such a breach has occurred, all other states are under a duty to cooperate to bring that breach to an end, so they must act collectively. They must not recognise that breach as having legal consequences. They must not aid or assist the continuing breach. And the Namibia case is our authority there. So that's breach. Now let's discuss, in effect, defences, circumstances precluding wrongfulness. So the point here is that an act will not be wrongful and legal responsibility will not arise where one of the six following applies: consent, force majeure, distress, necessity, self-defense, and countermeasures. So obviously, if a state has consented to an act, say the stationing of troops inside its border, that's not a wrongful act of aggression because it's been consented to. So consent is always, as it were, a valid defense. Force majeure. This requires an irresistible force or an unforeseen event, which was neither foreseen nor easily foreseeable, that was beyond the control of the state, that is, the state was unable to avoid or oppose it, and it makes the performance of the obligation materially impossible. And note, impossible, not difficult. So, for example, an obligation that requires the continued existence of a particular object, say the return of an occupied building, such as a lighthouse at the end of a war, if that's destroyed by hostile enemy action during the war, well, you cannot return literally that lighthouse, it's gone. Distress. So this covers cases where a person whose acts are attributable to the state has no other reasonable way of saving his or her life or the lives of other persons entrusted to his care. So, for example, landing an aircraft without permission under force of weather, or deviating into another state's airspace to avoid a storm, and we'll talk about some of those cases in class. Necessity is quite a strict test. It cannot be invoked unless the act is the only way for the state to safeguard an essential interest against a grave and imminent peril, and it does not seriously impair an essential interest of the state or states towards which the obligation exists, or the international community as a whole. So, safeguarding an essential interest from a grave and imminent peril. Self-defense under the UN Charter is a valid defense, and countermeasures, as we come to in later sessions.